So welcome to those who are coming on. I'm starting the recording, and today we're presenting the 2021 Caregiver Support Webinar Series. It's presented by the California Department of Social Services and the California Alliance of Caregivers. In May, California celebrated the 20th anniversary of the Foster Youth Bill of Rights, and we're focusing on the Foster Youth Bill of Rights and what caregivers need to know. I am Summer Rolfe, a program analyst from the Resource Family Support and Permanency Branch at CDSS and your facilitator today. This webinar is being recorded and it will be available at the link that is posted, that is www.caregiver.org/webinars, and it will be posted in the chat, as well as the information will be sent out. All handouts, slides, and this recording will be emailed out to registered participants after the webinar. If you would like a certificate of attendance, please email your request to info@caregivers.org as listed in the chat. Participants will not have the ability to speak today, so please put all of your questions in the Q&A section, and they will be addressed at the end of our presentations. And here is the agenda for today. I'm going to start us out, and then you're going to hear about a historical perspective of change from Jennifer Rodriguez, the Executive Director of the Youth Law Center. After that, we're going to hear from Kendra Predo and Kendra Jackson of the California Office of the Foster Care Ombudsman, and they're going to talk about the Foster Youth Bill of Rights and the caregiver. After that, we're going to hear from a caregiver's perspective from Jennifer Rexroad, the Executive Director of the California Alliance of Caregivers. And then the question and answer section is going to be facilitated by Lily Colby of DSS. And I know that as caregivers, you open your hearts and your homes to children across the state, and you might be very familiar with the Foster Youth Bill of Rights, but you might want to know more about how these rights affect you and the children in your care. How do you walk the line when it comes to sensitive issues such as cell phones and social media, or chores and allowances? Today, we're going to answer these questions, and we're going to have a discussion. If you post in the Q&A, then we will present these questions that you have to the panelists and get you some answers. We're going to begin today with a video, as I mentioned, and it's pre-recorded by Jennifer Rodriguez, the Executive Director of the Youth Law Center, as she describes how her lived experience as a foster youth led her to the California Youth Connection and helped them to create rights for youth in foster care and create the first ombudsperson's office, leading the charge in California and setting an example for all of the other states to follow. First, I would like to introduce you to Jennifer Rexroad, the Executive Director of the California Alliance of Caregivers.
Good afternoon, everyone. Thank you for joining us this afternoon. We acknowledge that you as resource parents are on the front lines of upholding foster youth rights, and by providing foster youth with the excellent parenting they need to heal and thrive. With that in mind, I'm going to share a message from Jennifer Rodriguez from the Youth Law Center.
Happy 20th anniversary to the Foster Youth Bill of Rights. I'm Jennifer Rodriguez. I'm the Executive Director and a lawyer at the Youth Law Center. Back in 1998, I was a member of the California Youth Connection, and we decided that creating rights for youth in foster care and figuring out a mechanism to enforce them was our top priority. Too many youth had experiences like I had, being isolated in restricted group home placement, far away from home, where anything could really be done to us without consequence. Those experiences range from small harms to big harms. My own experiences were not unusual. Having earnings from a summer job digging ditches at the Conservation Corps disappear from the locked cash box in the staff office, being left out of school for months after I moved placement, not being able to talk to my dad who was incarcerated for years because he could only call collect, my placements wouldn't accept collect calls, having to shoplift personal products like deodorant and tampons when placements refused to provide them, being forced to take psych meds when my sleeping schedule didn't match the facility structure, having police kick me out of a placement in handcuffs to sit for a day in an adult jail cell before going to juvenile hall because I fought back against a staff who was sexually abusive. Despite having a social worker, a lawyer, a therapist, and all kinds of other professionals being paid to ensure that our needs were met, there was no one who could take action. When we tried to seek resolution, our concerns were often minimized, dismissed, forgotten about, and at worst, we weren't believed or we were punished for raising the issues. It was frequently our word against adults' words, and we always lost in that fight. It felt like since we were in foster care, rather than being safer and more protected, instead, we lost status as a child and we lost all of the things that define a childhood, namely adults to care for us and make sure we were okay. Something had to be done. We had tried several times to introduce a group home bill of rights, but providers fought back successfully. Finally, with the support of the Youth Law Center, we were able to craft the bill that consolidated all of the existing rights of youth into one place and required notification of youth. We successfully passed the law that created California's first foster care bill of rights. At the time, our focus was on making sure that youth and those who had responsibility for their life knew the basics of how we should be treated. We had no idea that our Bill of Rights would be held up as a model for states across the US and ultimately adopted into federal law. Our focus wasn't changing national systems. It was simply protecting future children from the long, painful list of abuses that had happened to us. We also knew that rights were going to be meaningless unless there was someone who could call if they were violated. What most people don't realize is that all of the rights in the Foster Youth Bill of Rights had existed for years prior to our bill. But youth didn't know, and there was no way to enforce those rights. We knew we needed someone to enforce who was youth-focused, who would believe youth, who understood the law well, who would treat youth consistently, no matter what county they were from, what kind of placement they were in. So CYC also worked to create the first ever foster care ombudsman's office in the entire nation that was solely dedicated to educating and enforcing youth rights. I was lucky enough to have had the chance to work with the first foster care ombudsman, Karen Grace Cahill, as her first student assistant in Sacramento while I was in community college, and to help set up the office and set the protocols. Karen was a pit bull in plurals, totally committed to thinking about the children and youth we were mandated to work for as her own children, and demanding nothing less than she'd want for her own. In those first days at the Ombudsman's office, we traveled all across the state, meeting with youth, resource parents, group homes, social workers, probation officers, lawyers, and advocates, anyone and everyone who would listen, to make sure they knew youth had rights in foster care, to make sure they understood how those translated to real life, and answering questions. Every single presentation we did ended in at least one person taking us aside at the end to make a complaint. Usually they had no idea until they talked to us that they had rights or that anyone would believe or care to enforce those rights. Again, youth complaints detailed hundreds of ways that their childhood had been stolen from them in foster care. Youth who hadn't been able to see the people they love most in the world, their extended families or siblings in too long. Youth who were denied the right to go on sleepovers. Youth whose cell phone, lifeline to the world, was taken when they entered a placement. Youth who hadn't received a clothing allowance in order to buy underwear that fit. Youth whose social workers never returned their calls. Parenting youth who had CPS remove their baby because they had been moved too many times. Youth who were worried that they'd be homeless when they left foster care. The Ombudsman's office was the only place that so many of those youth had to turn. We listened carefully, took their concerns seriously, provided them information to self-advocate, investigated and notified their attorneys and social workers. We notified community care licensing when a placement wasn't meeting standards, and we made sure that staff and leadership knew that they needed to do a better job ensuring counties followed the law and improved their practice. In those days, as now, the Ombudsman's office was a critical reminder for CDSS of who child welfare is supposed to focus on, the child. While there are now more laws, more protections, and more rights, too many children and youth, unfortunately, still experience the same disregard of their childhood. When Rochelle was appointed as ombudsman, she represented a vision come true for those of us who advocated to create the position and office. Being appointed the protector of rights of children within a system that's not structured to deeply respect and honor those rights is truly a challenging job. However, if we as youth advocates in CYC had imagined the kind of advocate who could do justice to this role, Rochelle would have been that person. Rochelle couldn't have come at a more important time. She firmly established the Ombudsman's Office as the moral conscience within CDSS, representing the rights of the most poorly served youth in policy discussions. Rochelle and the Ombudsman staff tirelessly have upheld the mission of the office through political and priority changes, and they have made the rights powerful and real. We are now at another critical moment. The pandemic has turned the lives of so many youth in foster care upside down, adding additional instability, disconnection, educational loss, isolation, and sadness. While California policy should be moving away from group care, we're still struggling to fulfill our promise of the most basic right, that every youth, every day, lives in a nurturing family where they can receive the most important thing we can offer them, excellent parenting. We know there's still much work to do. Just a couple months ago, the last of over 100 youth returned to California after out-of-state foster care facilities that were characterized by national news sources as profitable death traps due to their abusive practices, deplorable conditions, and little oversight were finally decertified by CDSS. These are the youth the Ombudsman Office was created to serve and protect, and these are the rights that the office makes into real commitments. For the future, it's more important than ever that we ensure the Foster Care Ombudsman's Office can live its mission of protecting and enforcing the rights of youth. There's much to celebrate. The reason we're having this meeting today is due to the power and advocacy of those who have worked to make life better for other youth like them. At 20 years in, though, there are also questions we should be asking ourselves. Do we feel we dedicated the appropriate amount of resources, power, and attention to enforcing the rights of youth in foster care? Do we do everything possible to place the rights of children to depend on us over the interest and convenience of adults in this system? Do we make every policy and decision in California from a starting place of what children need developmentally to thrive and what is going to produce a healthy, happy 40-year-old? Does the office we've mandated to protect and enforce the rights of youth have the staffing that reflects the important role it plays in ensuring quality care? Does it have the structure and independence needed for the appropriate power and influence the office should have? Do we need new accountability for foster youth rights? Are there new roles for the office in bolstering youth involvement, quality improvement, and reform in counties across the state, so that protecting the rights of foster youth becomes the way that we do business in child welfare, rather than something we think of after we've already inflicted harm? These are the questions that I hope that we can work together to answer as we celebrate 20+ years of foster youth rights in California. Thank you so much.
So Jennifer posed some really good questions for us all to consider and think about. I would like to now hand it over to Kendra Predo and Kendra Jackson of the California Office of the Foster Care Ombudsperson.
Hi, everybody. Hopefully you're all able to see the presentation. Is it visible to everyone?
Yes, that looks good.
Excellent. Hi, everybody. Thank you so much for attending this caregiver webinar. My name is Kendra Predo, and I'm from the Office of the Foster Care Ombudsperson. And today I'm really excited to be joining with my colleague Kendra as we talk to you all about the Foster Youth Bill of Rights. Again, I am an analyst with the office, so my main role is monitoring the hotline calls that we receive from callers throughout the state of California, as well as investigating cases that deal with foster youth rights violations, their care, placement, and services. I also assist with facilitating training such as this one, and also help as well with developing publications and curriculum that teach everyone about the foster youth rights. And again, I'm really happy to be here with all of y'all to go over the Foster Youth Bill of Rights, and I'll pass it over to my colleague Kendra to introduce herself as well.
Good afternoon, everyone. My name is Kendra. I am also an analyst in the Office of the Foster Care Ombudsperson, with Shekinah. So excited to be here to present to you guys today on the Foster Youth Bill of Rights. Um, just like Shekinah, I do take intake calls regarding complaints that have to do with the care, right, placement, and services of youth who are in foster care. I also facilitate trainings, investigate a lot of complaints, and provide the foster youth verification letters to former foster youth and youth in care who would like to go on to college and obtain higher education. So there's a lot of duties working on curriculum as well. So our job, we do a lot of things just in that one office. But again, just so excited to be able to be here today to provide you guys information on how to uphold the rights of youth in foster care in the state of California. So the learning objectives for today, our goal is for you to learn about the role, functions, limitations, and the laws that govern the California Office of the Foster Care Ombudsperson, or as you'll commonly hear us say, OFCO or OFCO in abbreviation, to learn about the OFCO complaint process, to learn about the California Foster Youth Bill of Rights, and importantly, to learn about how to identify potential foster youth rights violations and uphold those rights.
All right, so before we get into what our office does, I'm here to clarify what exactly an ombudsperson is. So an ombudsperson or an ombudsman is an individual who is an impartial, independent person who has the authority, responsibility to receive, investigate, and or informally address and resolve complaints about government actions, and when appropriate, make systemic recommendations based on findings. Definitely a mouthful of a definition, but essentially what it means is that an ombudsperson is a sort of watchdog, an independent third-party person that oversees a specific government system. So essentially within our office, the Office of the Foster Care Ombudsperson, you can kind of guess which system we oversee, and that would be the California Child Welfare and Foster Care System. So that is our main duty and role, is to be impartial, to be independent while we receive, investigate, and informally address these complaints.
So our roles, which goes into a little bit more about what do we do. So the Office of the California Foster Care Ombudsperson is, again, it's a neutral and independent office, and our role is to help solve problems and complaints, again, about the care, placement, and services of children and youth in foster care. We help foster youth, social workers, probation officers, resource families, and advocates understand the rights of children and youth in foster care. And we also help by making policy recommendations to improve the foster care system. So if you're concerned about the rights of a child that is in foster care or issues related to their care, placement, and services, then our office may be able to help. So what we do a little bit more is the OFCO provides former foster youth in California with dependency letters, also called verification letters or word of the court letters, which entitles them to resources. Again, priority registration for financial aid, access to the Chafee grant, priority registration and admission in college, other resource programs at colleges like EOP and EOP&S, Guardian Scholars programs. Those letters provide proof that they've been in foster care to give them access to those resources. Again, what we're doing today, our office provides trainings on the services provided by our office on the Foster Youth Bill of Rights and on reasonable and prudent parenting standards, which we call RPPs. And we also provide free Foster Youth Bill of Rights publications to foster youth, county child welfare and probation offices, foster family agencies, congregate care agencies, shelters, group homes, and STRTPs as well.
Mm-hmm. All right, so Kendra did an excellent job of explaining what our office can do and the duties that we are able to perform. So our office actually also has some limitations. So some things that we are not able to assist with. I mean, I did see a question pop up in the chat regarding if court is involved with this. So actually, court is actually one of our limitations. Within our office, we do not have the ability to change any court orders or case plans. We also do not have the ability to address any personnel issues. So overall, that means that whatever a judge orders would oversee our office ability to intervene. And any case plans established by the social worker would also be something that we could not intervene on. Common calls that we get with our office are related to social worker conduct or individuals who are unhappy with how the case is being handled. So unfortunately, our office does not have the ability to discipline or fire or change social workers. However, one thing I do want to note is that even though our office does not have the ability to do these things directly, we can still share with people who call us how they can go about asking for these things. So for example, if someone called us to ask for a change in court order, we would share with them to file a JV 180 in the courts to request a change in court order from the judge. Or for example, if somebody wanted to change a specific aspect of their case plan, we would let them know that they can call a child and family team meeting to ask about that with the social worker. Then in regards to personnel issues, we would know the contact information for the social worker supervisors and also the county grievance process so that that individual can request that somebody intervenes or even requests a new social worker. So again, we do not directly perform these changes, but we can teach our callers how to do it. Some additional things that are within our limits as well is that we are not an emergency response team. So emergency response calls are made again and investigated by the county. So we know the contact information for those, but we ourselves do not go out to do in-person investigations of child abuse and neglect. We also don't investigate complaints about judges, attorneys, and law enforcement. Those are within different jurisdiction. And then we also don't provide legal advice as well. We can give legal information, but we do not provide advice on how to go about navigating the courts. And then we also don't investigate issues related to child custody, child support, and family court. And we get a lot of calls related to that as well. So again, overall, just to summarize our jurisdiction, it's about youth in foster care and their care, placement, services, and rights.
So the majority of our day, we do a lot of things, but we do take complaints on our hotline. So again, Shekinah and I are both intake and training analysts, so we do these intakes and these trainings. So the basic part of our complaint process is when a person calls us to make a complaint, is that we're going to listen to the complaint. Then the next thing is we're going to investigate the complaint. And the first part of the investigation is basically more of a screening process to see that if it is something that falls under the jurisdiction of our office. The third step will be to resolve the complaint, and we will work hard, as it says, to resolve the issue or complaint that you have. And if it's not something that can be resolved within our office, then we will recommend you to this appropriate entity that was able to help you. So our primary complaints and the priority that we give are to the complaints that we receive from foster youth. So our office was created to serve foster youth, and those calls again are our first priority. So anyone who is concerned about the care, placement, services, or rights of a child or youth in foster care can contact our office. These calls are confidential calls. So we do have a confidentiality policy to protect the identity of people who call to make a complaint. The law does allow us to release certain information to certain people in the process of conducting our duties. However, if we need to share this information, we will inform you. If there's an immediate safety issue, we may also make a report to the appropriate agencies, such as the county's Child Protective Services, CPS agency, or the Community Care Licensing Division. If this happens, we will also discuss this with you. That would occur if the complaint that we received had any allegations of a child abuse or neglect, we would cross-report to CPS. And if it was, again, a complaint involving a youth and also involving staff in a group home or STRCP, we would also cross-report this incident to Community Care Licensing. So once all this happens and you contact us during the resolve and the recommend part, is we respond to those foster youth complaints within 24 hours. Again, those are our first priority and the reason why our office was created. If a youth calls to file that complaint, we tell them we'll respond to them within 1 business day. Any person who can file a complaint on behalf of a child in foster care, as long as the concern is about care, placement, and service to the foster child, then those are the ones that we review to determine if it needs further investigation. And again, some complaints, as we said, may be recommended to other agencies for resolution. If we do choose to investigate the complaint, though, we will notify you of our decision, and we will again offer periodic updates, and we will notify you about the closure of the complaint as well. And just to know that the complaint will include a review of like the records, case file, contact with relevant agencies, or interviewing certain people such as social workers, probation officers, or staff at the group home or STRTP who are named as involved in the complaint.
Right, now we're going to get into the big main meat and potatoes of this presentation, which is the Foster Youth Bill of Rights. So as Jennifer explained in her video, the Foster Youth Bill of Rights was a result of really intense advocacy from youth advocates from California Youth Connection and youth throughout the state who really wanted to establish a Bill of Rights to ensure their protection and ensure that their rights were being upheld while they are in foster care. So within the state of California, all California youth who are in foster care have these rights. These rights also apply to any youth that are on probation and live in an out-of-home placement, such as an STRTP, so short-term residential therapeutic placement, a group home or foster home, as well as any other children living in any licensed or certified children's facility or home in the state of California. So again, this is who the rights apply to, youth who are in foster care and have an open dependency case, or a youth who is on probation, doesn't have an open dependency case, but happens to be in an out-of-home placement. And again, that also applies to youth who live in licensed facilities. As Kendra has mentioned, one of our main roles is also working with other state agencies and making cross reports. So for the youth who do not have an open dependency case and also do not have a probation case, we can still make cross reports to community care licensing to ensure they are being treated fairly while they are in a state licensed facility or state licensed foster home. And for the sake of reference, if you all want to follow along to some of the rights that we have, I did list our link inside the chat if you want to learn more about the rights. Our website lists all the rights per category, which will be something we're going to go over in the next slide. So if you want to follow along or learn more, you definitely feel free to take a look at the link and check it out.
Okay, so now we're going to talk about Assembly Bill or AB 175, which was the update to the Foster Youth Bill of Rights. And so AB 175 was signed on October 2nd, 2019, and it updated the Foster Youth Bill of Rights and clarified the role of the foster care ombudsperson as providing training and technical assistance regarding these rights. The bill went into effect in January of 2020. Now, in the beginning of the webinar, Summer did highlight that we did just celebrate in May, in Foster Care Awareness Month, the 20th year anniversary of the actual Foster Youth Bill of Rights. So we were so excited to be able to include like the update, because it now includes 41 rights for youth in foster care. And what AB 175 did, in addition to adding these additional rights, is that it reorganized, clarified, and expanded the previous Foster Youth Bill of Rights, and it put the rights thematically in category, making it easier to access the rights and knowing like exactly what you're looking for. It's like categories that are related to, we'll go over this again in another slide, but like the placement and well-being, personal rights of youth, communication, cultural ceremonies, extracurricular activities, their medical care and records, their education, financial literacy, their case plan development, proceedings and records. So we'll talk about that a little bit more, but we're just really excited because it added more rights and clarified it. And again, with all these wonderful publications that Shekinah just put the link to in the chat for youth of any age to be able to know and understand their rights. So Shekinah will talk more about that in the next slide.
All right, so speaking of publications, as Kendra said, AB 175 not only updated the Foster Youth Bill of Rights, but it also created new mandates within how we engage with youth and also any of their adult supporters about the rights themselves. So AB 175 actually mandated that our office create curriculum that is to be used throughout the state to educate youth and also any adult supporters such as resource parents, social workers, and any other providers about the Foster Youth Bill of Rights. So these publications that we have listed are created in order to support that mandate so that individuals who are supporting a youth in foster care are able to know about the rights, and so that the youth also know the rights as well. So in November 2020, we updated these publications, and we now have a coloring book for the younger kids in care, a teen handbook, a pocket accordion folder that you can use and keep in a pocket and be able to unfold into a brochure, as well as a poster that is going to be posted for any of our congregate care facilities or any home that has more than 6 foster youth within the home. We have these available on our website, so you can download the handbook and also the coloring book. We have both English and Spanish versions. The poster and the accordion brochure can all be ordered and pre-ordered online, where you can actually request a printed copy. So currently, as we speak, we're in the process of printing those documents and working with different printing agencies to make sure that we're able to get a great order to send this around to the state of California, so that hopefully all people will be able to know about the foster youth rights. And then one thing we'd also want to highlight as well is that these publications were made with the input of Youth Voice. So our office actually went out and performed focus groups throughout the state to actually ask youth how they would best like to be informed about their rights. And surprisingly, a lot of the youth actually wanted these paper documents. They actually preferred a hard copy of their rights over digital. So we decided to do both and make sure that we had both types of versions available for them so they could learn about their rights.
So to go a little bit more into the categories of the Foster Youth Bill of Rights, which I said being that is now organized into themes and categories, makes it easier to access basically which right it is that you need more information on, that a youth might feel or an advocate might feel that is being violated. There's a category of personal rights, their right to live in a safe, healthy, and comfortable home and be free from discrimination and abuse. We have the ICWA, or the Indian Child Welfare Act rights that pertain to youth who have the Native ancestry. There's SOGI, which is the sexual orientation, gender identity expression, which expresses that youth have the right to be addressed by the pronouns that they choose to be. That is a right. So even if on paper or when a youth entered foster care, they had different pronouns, they have a right to be addressed by the ones that they actually choose to be addressed by. There's educational rights pertaining to graduation credits for youth who are in foster care. What happens if something happens at school, that they're able to, what are they able to do, to a foster youth as far as with educational discipline, that they actually have additional rights. There's the sexual and reproductive health rights, mental health, their case plan, their CFT, their family connections, because one of their rights is that they do have a right to maintain social connections with people outside of the foster care system, especially if they have siblings in the foster care system, to maintain those connections as well. But as far as outside people before they entered as well, and financial literacy, which would be the adulthood and money management to prepare them for when they actually exit foster care.
So with all of these new rights categories and over 41 rights, the question comes up as to how do we let youth know that they actually have these rights? Well, there's actually a mandate that states that social workers, as well as probation officers, must review the rights with youth once they enter care, and also every 6 months and before every placement change. So there's actually a law that states that this needs to be curriculum that is reviewed with the youth. Unfortunately, oftentimes our office hears that a lot of youth actually do not know about the rights or have never heard of them, or even more unfortunately, once they leave care, that's when they realize that they've had rights in the first place. So again, the fact that these publications were created, the fact that our website has been updated, and the fact that we are coordinating these trainings is a way to bring awareness on the fact that this does need to be common curriculum for the youth once they enter care. An additional part of that mandate is that youth must also be given contact information for community care licensing and our office at each placement. So to be given the information on how they can file a complaint with us or community care licensing, and also how they can feel empowered to advocate for themselves if they feel like a right is being violated. Youth also have the right to contact our office and community care licensing confidentially, and also to not be punished for making complaints. So oftentimes our office, especially with youth who are in congregate care facilities, at times when they call us, there might be an individual or staff member actually listening in or trying to monitor them during the call. Sometimes I, and Kendra probably as well, have had to go on speaker to inform them that the youth has the right to speak to us in private. So if that is necessary, if that's something we have to do, we'll definitely do that too. And then in terms of not having to get punished for making a complaint, youth have the right to do that and to express and to advocate for themselves, so long as they feel like their rights are being violated, and they should not be punished for doing so. And they actually have the right to be protected from retaliation if they end up doing that as well. So again, we do have a lot of categories, a lot of rights here. We wish we could go through each and every one with all of you all, but given the time that we have, we wanted to make sure you all at least know the categories and are familiar with it, and definitely take a look at our website to get familiar with the publications so you know the rights a little more intimately.
Yes, so as Shekinah said, there are a lot of rights. So this was just the categories is just a brief overview of what some of the rights like entail, but there are a lot of them. So again, we're gonna play a game. We understand that we didn't get to go over all the rights, but we have a game that we like to play, and it's just to test the knowledge of knowing if, and it's called, is this a foster youth bill of rights violation? So what we're gonna ask you to do is listen to the following scenarios and determine if you think it's a potential foster youth rights violation. If you think that it is, we would like you to type yes in the chat, or if you think that it's not a possible rights violation, we would ask you to type no in the chat box. And then it says, and explain your reasoning on basis on why you chose yes or no. So we can go ahead. So kind of, you want to do the first scenario?
Yes, and don't feel bad if you don't know the answer. Again, it's not about being wrong. It's just about learning and figuring out how to balance parenting decisions and the foster youth rights. So give it a go, even if you're not sure. All right, so here's the first scenario. Two siblings are placed in your home. You decide to give the 16-year-old an allowance, but not the 10-year-old. Is this a foster youth bill of rights violation? Ooh, all right, so we're looking into the chat. We see a majority of yeses. And we see a reasoning that someone stated that yes, because all youth have the right to an allowance. Oh, fantastic. All right. So we do have a mixed bag here, but we do see a majority of yes. So in this case, yes, this would be a rights violation because according to the Foster Bill of Rights, all youth have the right to an allowance, an age-appropriate allowance. There is no age limit to this right. So we tend to get this a lot is if I, as a resource parent, decide that a youth may be too immature or not able to understand the concept of money, can I not give them an allowance? So the answer would be no, you would still have to give them an allowance, but where RPPS comes in and where you can be creative as a resource parent is you can use alternative forms of an allowance. So for example, if the youth is a younger child who doesn't understand the concept of money, you are willingly able to use, for example, a point system where a certain amount of points leads to a fun day at an amusement park or a new video game. Or you can use Monopoly money as a way to trade either certain toys that the youth wants or candies that the youth wants. And for our older youth and teenagers who understand the concept of money, using an allowance. And one thing I want to note is that there is no matrix, there's no table or calculator defining the minimum amount for a youth. So that is where the resource parenting comes in, where you all are able to determine how can I establish an allowance that will best make sense for this youth so they understand how to handle money and they know how to deal with having to budget and manage. So some of the resources parents that I have spoken to or have gotten calls from, some of them get a little creative. So for example, one resource parent who was taking care of a 17-year-old, they created an allowance that was based on the state minimum wage. And they calculated it as if the youth were working 20 hours a month and how much would they get. They did this because they wanted the youth to understand how they would manage real income if they were actually going to work. So that's one thing that a resource parent did. Another resource parent did allowance based on that youth's age. So a 12-year-old got $12 allowance per week, and that would be the way that they did it. And again, another resource parent with a 5-year-old set it up using point systems instead that related to toys and events and things like that. So again, that's where the flexibility comes in. And I do want to note as well, though, that if it is a congregate care facility or a foster family agency, that they tend to have that matrix set for them within that agency. So if you are from that congregate care facility or from that agency, that would be something that you would refer to. But in general, if that does not apply to you, that would be where RPPS comes in.
Okay, the next scenario is a youth in your home is upset after a court hearing. They begin to cry, yell, and threaten to throw objects around the room and leave the home. You state that you will call the police if they do not calm down. Is this a foster youth bill of rights violation? Okay, so I see a couple of yeses and then I see some no's in the chat. So the answer would be yes. This would be a foster youth bill of rights violation, and it is because the youth, they have a right to be in a placement and have caregivers who are trained in trauma-informed and evidence-based de-escalation intervention. So they have a right to have caregivers, probation officers, social workers, and attorneys who are trauma-informed. So law enforcement is not to be used as the first mode of intervention unless there is an immediate threat to life or safety of a person or as a last resort. So that's established in the Welfare and Institutions Code 16001.9, again, to have a placement that utilizes trauma informed and evidence-based de-escalation intervention. Basically, what I just said to you is established in the Welfare and Institutions Code regarding youth who are in foster care, and not to have the police or law enforcement intervention used as a threat or in retaliation against the child. What's wonderful about it is that I think that the Caregiver Policy Unit has resources for caregivers, and they actually have a family urgent response system with the acronym known as FIRST. And there's a website and there's a toll-free hotline that includes the following services for caregivers. So that hotline is available 24 hours a day, 7 days a week, and is staffed with caring counselors trained in conflict resolution and de-escalation techniques for children and youth impacted by trauma. There's a county mobile response system and stabilization teams also available 24 hours a day, 7 days a week, that they provide in-home de-escalation, stabilization, conflict resolution, and support services and resources for caregivers. There's ongoing support services beyond the initial mobile response, so they won't just come out, because they'll come out. They won't just come out and then be like, okay, but they will continue to follow up with the case to provide continuous support. And the hotline and mobile response staff are trained in working with children and families who have experienced trauma. So even if you're, a caregiver and that's something that, is new to you, then you do have resources available to you to assist you in de-escalation and in providing trauma-informed care to foster youth.
All right, here's the next scenario. A youth comes back to your home after going on a field trip at school. You search their backpack to make sure they are not bringing back anything inappropriate. Is this a foster youth bill of rights violation? All right, so we're getting a mix. So I'm getting a mix, but a majority seems to be yes. All right, and then a lot of explanations are in regards to you have a right to a measure of privacy. It's a violation because it's an unreasonable search. And to that, I want to say those who said yes, you would be correct. So according to the Foster Youth Bill of Rights, specifically right number 10 in Welfare and Institutions Code 16001.9, you have the right to not have anyone look through their things unless there's a reasonable or legal reason to do so. So we get a lot of questions about how do you know and what determines a reasonable reason to search a youth's items. So for example, if a youth visibly, as you can see from their face or their smell, and you have suspicion of, for example, drug usage, that would be one way for you to engage with that youth and ask them about their appearance and about their behaviors. Or for example, if you suspect that the youth is behaving differently, may have something that they're hiding in their backpack or so forth, that would be where that would be reasonable. However, one thing I want to note to people is that the first reaction to and any change in this behavior shouldn't be immediately to go through their bag, right? It's to use that relationship that you have with that youth to communicate with them first, to see what's different about them, what's wrong, to sit down and talk to them so that it doesn't have to escalate to that point where you are having to search through their personal belongings. One thing we really like to highlight is to not use that youth's past against them. So especially for our youth who are on probation or have had a history of gang-related activity or drug usage, or even our CSEC youth, oftentimes their history has been used as a way to justify searches, even if there is at that moment not a reasonable reason to do so. So we definitely want to avoid that and make sure youth know that their past will not be held against them, and that every day is a fresh new start for them. So that's one thing that we always like to highlight, is to make sure to engage with the youth one-on-one for communication prior to trying to go into the searching. And if you are concerned about searching, contacting the social worker or the probation officer about your concerns would definitely be a good next step.
Okay, next one. A youth uses a messaging app to stay in touch with friends. You remind the youth to be safe and appropriate when using social media. Is this a foster youth bill of rights violation? Yay, everybody said no, and no, no would be the correct answer, because although having social media is not a right, the youth does have a right to use a computer and the internet. And if they are using social media to maintain connections with their family and friends, it is encouraged that social media be used. Caregivers are also encouraged to discuss the safe internet and social media usage with the youth, which would again be another example of the reasonable and prudent parenting standards, or RPPS, that we talk about. So the same with code, the 16001.9 gives a youth the right to participate in extracurricular, cultural, racial, ethnic, personal enrichment, and social activities, including but not limited to access to the computer technology, the internet, consistent with the child's age, maturity, and developmental level, sexual orientation, and gender identity and expression. And also, again, to have this right to use the computer and the internet to maintain and visit with family members and relatives privately, again, unless prohibited by a court order, which is one of the rights, and to make and send, receive confidential emails. So they have this right. And again, to have social contact with people who are outside of the foster care system, that might be community members, pastors at a church, teachers, coaches, or anyone. So they do have that right. So very good, because no, it wouldn't be a violation. It would actually be more of a reasonable parenting standard, just to make sure that they were safe. So very good, everyone.
Here's another cell phone question. A youth purchases a cell phone after saving money from their part-time job. They are not following the phone rules that you set, so you decide to take the phone away from them. Is this a foster youth bill of rights violation? Right, I'm also getting mixed yeses or nos, but I'm getting majority yeses. You all are excellent. Right when I finish the sentence, you all already have the answers, and you have really great reasoning and explanations as well. All right, so in this case, it would be a rights violation, as according to the Foster Bill of Rights, you have the right to make, send, and receive confidential telephone and other electronic communication. If that mode of communication is taken away, then that would be a rights violation. And if you all know about the most recent All County Information Notice, we'll also have that linked at the end of the presentation. ACIN number 13221 actually clarifies more of these cell phone rules. So one of the questions that are in the ACIN is if a resource parent is allowed to remove a phone from a youth if they had purchased it themselves, if they are not following the rules. And that answer would be no, that is not going to be an RPPS decision. Again, that would be a rights violation. However, as the resource parent, you are able to establish certain parameters and rules around cell phone usage. So for example, if that youth is violating the rules of cell phone usage, you are definitely able to do something such as saying, okay, you're not following the rules of that I set, then by 9 p.m., you're gonna have the phone off and you cannot have it within this time, and the curfew to use the phone will be early. So certain parameters such as that, you're able to set as the resource parent. so long again as that youth has access to that phone, because the youth would be able to and has to have contact with their attorney, social worker, or office, etc. And then if you have more questions about what would be considered parameters that you can set, again, we'll have that ACIN linked so that you all be able to look at it. It's a really great resource, and it answers a lot of the questions surrounding cell phone usage.
Okay, so I'm expecting everyone to get this one right because Shekinah just gave you all the answer. So I'm going to go ahead. A youth is placed in your home. The youth has a cell phone that they receive from their parent as a gift before entering foster care. You have a rule that everyone needs to put their phones away by the 10 p.m. curfew on school nights. Is this a Foster Youth Bill of Rights violation? Yes or no? Okay, very good. And you all would be correct that no, because again, as a care provider, you may place reasonable restrictions on cell phone use provided that those limitations do not effectively deny the youth the right to use the cell phone unless the limitation has been approved by the social worker, probation officer, and RFA written directives. So again, it goes back to that all county information notice, or ACIN, the 13221, that Shekinah spoke to you about, that she said that it will be posted in the chat, that about collaborating with youth. And I think I saw that in the chat that somebody put that it should be a compromise. So it is a matter of providers and caregivers collaborating with youth, establishing cell phone agreements, and taking into consideration the individual needs that are unique to the situation. So like, it's not a violation to say that, hey, you can't use your cell phone during meals or doing therapeutic activities, or to conduct illegal activities, or not to share photos and videos, or recordings of other youth that are in the home without permission, and not to use the phone to contact people on your no contact list. 10 p.m. curfew on a school night sounds really reasonable to me, and just and may not use it for certain apps that are known to be likely to use for exploitation or trafficking. So you guys are all right that no, it would not be a violation. So very good.
All right. Great job, everybody, for going through those scenarios. And a lot of those are actually based on real life calls that we've had, or cases, or examples that are listed in the ACLs and ACINs that the state has put out. So overall, the main summary of what we want you all hopefully to get from this entire presentation and also this activity is that as a resource parent, the Foster Bill of Youth Bill of Rights is essentially meant to empower you, not hinder you as a resource parent that can care and provide for you. So again, we want to highlight that. The Foster Bill of Rights is not meant to be another legislation or regulation that essentially gives you all a hard time. That's not the purpose of the Bill of Rights. It was created to protect the rights of youth in care, but also to allow for that normalcy for them while they're in care. And part of that normalcy is you as resource parents being able to make those parenting decisions that support that for the youth. So overall, we know there's no official guide to parenting, but the Foster Bill of Rights is great because it actually comes pretty close. What it does is it provides guidelines and expectations for how children and youth in foster care should be treated. So in a way, it's kind of a pro. So you don't have to kind of do any guesswork about certain values or how to handle certain scenarios, because the Foster Bill of Rights lists already what should be happening. So essentially, when you are making a parenting decision, there are certain things that you should be considering prior to making that decision. And that would be existing court orders, the Foster Youth Bill of Rights, and then reasonable and prudent parent standard. So for example, one example I'll use is in regards to communication. So if a judge has ordered that a youth is not able to talk to their paternal uncle, it would not be a rights violation if you as a resource parent limited that youth from communicating with that paternal uncle. So for example, if you've noticed the paternal uncle trying to text the youth and you inform the youth that you're going to have to contact the social worker and set up limits to phone usage or figure out ways to either block that person, that would not be a rights violation because you're upholding whatever the order is from the court. And again, the court is the only entity that can either reject, deny, or change a foster youth right. And then in terms of the other aspects of communication, if the paternal uncle is not allowed to contact the youth, but according to the Foster Bill of Rights, the youth can contact all other people, then as a resource parent, you can support that Bill of Rights by allowing the youth to call friends, allowing the youth to text people that they know and family members, and allowing them and making sure that they have access to a phone or computer to do those things. So again, that would be a form of you upholding the rights as a resource parent related to communication. And then with everything else that is not explicitly defined by a court order or by the Foster Youth Bill of Rights, that's where you all can get creative as resource parents and use RPPs. So for example, you can set the times when a youth is able to be on the phone. You can say, please have your phone off by 9 p.m. on the school night. Or for example, you could say something along the lines of, if you're not listening to the rules of the phone, then you're not going to be able to play with those apps on the phone. So no more playing any of the games that you have because you're not following the rules. That would be reasonable. Or saying something along the lines of, while you're in online class, you're not allowed to use your phone until you finish your homework, and then that's when you can call friends, and that's when you can play games. So again, as long as it's not explicitly defined by court order or the Foster Youth Bill of Rights, that's where you can get creative and start using your different parenting styles to support normalcy for that youth, but also support the Foster Youth Bill of Rights. So whenever you are stuck on a decision, just kind of think of that order: court orders, the Bill of Rights, and then RPPs.
And so the last slide that we have would be the RPPS, or Reasonable and Prudent Parenting Standing Resources. So there's for questions and answers regarding reasonable and prudent parenting standards, there's the All County Information Notice, the ACIN 117-13. And then also another resource is the recommended practices regarding youth who have experienced commercial sexual exploitation, again, CSEC youth, and their usage of cell phones in the All County Information Notice, or ACIN 132-21.
All right, and that is our presentation. I'll go ahead and pass it over to our next presenter. And thank you all again for all your questions. Hopefully we'll have time to answer them at the end. Thank you all.
Thank you.
Shekinah and Kendra, thank you so much. That was a wonderful interactive presentation. I hope everyone enjoyed it as much as I did. I thought that was fantastic. And now I would like to pass things over to Jen Rexroad, who is the Executive Director of the California Alliance of Caregivers.
Thank you, Shekinah and Kendra. That was great to go over those. And I know that we're all, there's so much to know, so many rules and policies, and oftentimes, caregivers have not received the information for all of them in training. So it's good to know, and I love the new resource that has come out. So that will be linked in our materials as well, so that all participants can take a look through the new publications that have come out and reference back to that. So from the caregivers perspective, I'd like to share that I was a foster parent for about 7.5 years, and now our family is on a break. We're taking a break, but we had really little kids, and then we also had teens. We had a teen who was 17 and turned 18, and then became a parenting teen. So we had, so it felt like we dealt with some very different rights. And in fact, we kind of laughed a little bit that that when we started fostering, we had to post the list of rights on the back of or in the room. We taped it up on the back of the door, and we brought home a newborn infant from the hospital. And so that just seemed, kind of funny, because he couldn't read his rights at that time. And then I believe in the former version, it said that he had a right to 3 meals a day. So we also kind of laughed, because he ate far more as a newborn baby than the 3 meals that he was entitled to according to the Foster Care Bill of Rights. So I know that there are some that may seem, if you're fostering one age of a child, that may seem like they don't apply, and then you may have another youth that is where they would apply, and then you may have to refresh kind of what the current rights are. So the two issues that we often hear about from parents, and we ask for the focus of the presentation to be around media use and cell phone use, and then around allowances. So those are two areas where we thought there might be a lot of questions. And so we created a few resources. I'm going to share my screen here. So there's a great website. It's through a national media internet safety website on creating a family's media plan that I would highly encourage you to take a look at. I think that it's definitely okay to to uphold your family's values and to set age appropriate boundaries for screen time. Now, of course, we've been through a year where we've been on screens, so much for school and everything else. And we know that developmentally, too much screen time is not good for kids. And so kind of pulling in those boundaries and setting expectations, I think will maybe more of an issue over the summer and approaching next year. And I think there's a way to do this, while upholding rights. I know that in my household with two teens, that screen time can be used as a way to get homework and chores done, so that we set kind of the boundaries of you work first and you get your schoolwork done first, and any chores, and then the screen time is a reward, or it comes after that. I think for foster youth in particular, there are ways, I think, that some families you could have a phone that's used for always contacting an attorney or a family member or a sibling or somebody else that may be different than a cell phone. So this, I guess, would be a situation where the cell phone doesn't belong to the youth, but they may have a limited time on screens on an iPad or a smartphone or a computer, and then but still be able to have that freedom to contact and maintain connections that would be outside of that screen time. So I think setting up a situation that works for the age of your youth and your particular situation is really important. I know that when my kids were younger, I used a Circle app by Disney. I know there are a lot of different, Bark is another kind of screen time or monitoring app that allows you to only allow a certain amount of time for certain activities. So I had certain applications that I didn't allow my younger teens to use, and they had so much time on screens, and then the Wi-Fi turned off for them. And so that was a way where I didn't have to grab phones or yell or say anything. It was all controlled by by the circle device, and they knew what the rules were and what was going to happen. And it makes me think about our trauma training that we do on being a trauma-informed caregiver. Part of that training talks about how a lot of our kids have issues with food. And when you take away, they maybe have a box of cookies and they're, eating a bunch of cookies right before dinner, and how you're not supposed to take away the cookies or take away the food because that's an immediate trigger, where you might say, please put the cookies down for after dinner, or you can have the cookies down after dinner, or, designate what the child is supposed to do with the cookies without taking the cookies directly from a child. And I think that is a lot. I think the same can be said with technology, that I'm sure all of you have experienced this, that if you were to try to take away a phone or an iPad or a device from a child, a lot of times that will send a child just, it just completely out of control. So I think having clear, boundaries and thinking ahead of time of how to apply reasonable and prudent parenting standards, while also maintaining rights and also being a trauma-informed caregiver. You might ask that the youth put their phone at the charging station, when it's time for bed or when their screen time is over. You're not touching the phone. You're not being the bad guy. You're just directing. We put our phones here, at the end of the day when it's time to go to bed or whatever. So I think there, a lot of caregivers have kind of been stumped and have had a hard time figuring out how to keep kids safe and appropriate. And so we, I think figuring out what works for your family and the age of your child is possible. And we'll share some resources with you as well. The next area of concern for many caregivers was in giving an age-appropriate allowance. We've heard of some foster family agencies that have guidelines around ages and appropriate allowances. I haven't heard any policies or guidelines from counties, so that may vary around the state. Obviously, if your foster family agency has guidelines, you would want to follow those. And generally, it's thought that allowances given, for teaching financial literacy, delayed gratification, teaching kids how to plan, how to make decisions. I have always really appreciated the bad decisions my kids made with their allowance, buying something that 2 days later, it was broken or they didn't want it anymore, and to have that experience of making a bad purchase and thinking to themselves, I'm not going to do that next time. And it's also meant to give youth agency, we say, or a sense of control over this area in their lives. So they may want to save up money to get their sibling or mom and dad a gift, or to get some more art supplies or something that they really enjoy. But I think we all feel good if we can make decisions on how we spend our money. So I think thinking of it in that way is helpful for determining the right amount per age. I know that some caregivers do an allowance by age, so it's $1 each year. We conducted a survey, some of you may have answered it, about allowance, asking caregivers how they set up their allowance and when they gave allowance. And generally, we found that many find that rather than giving an allowance based on chores, that youth would have a set amount allowance each week, you know, whether or not they did chores, and then maybe they can do chores to earn extra money. Because again, if the youth didn't do the chores and then they didn't get the allowance, technically that would be a rights violation. So not tying it to chores or behavior, which also really goes in line with trauma-informed parenting, that we want our youth to have, to feel success and to be able to get past if they do have bad behavior or they're not able to kind of meet a standard if that was set for allowance. So a few of our dues were do give an allowance based on age and what the child and youth is expected to pay for. Do use an allowance as a way to teach financial literacy. Do use an allowance to practice delayed gratification. Do allow children and youth to make and learn from mistakes. And don't take away allowance as a punishment, and don't make allowance dependent on behavior. For my older teen, one older teen who had run away in the past, having a generous allowance at the end of the week, I think helped her to just get to that day. And then she received her allowance, and then, you know, breaking it down week by week and having something at the end of the week can be helpful for some kids, and something in their week that's the same and that they can look forward to. And we're going to be sending you a list of some resources that we found to be helpful. Many of them are from Parenting Magazine, and there are a few short videos and a great one on teaching little kids about money, because the sooner we can teach financial literacy, the better. So now I am going to turn it over to Lily to answer some questions that all of you have had.
Lily, you're on mute.
Thanks for letting me know. Thank you so much, Jennifer, for your wonderful presentation and the work that you did leading up to today, to survey caregivers, to ask questions, to find out what were some of the questions caregivers had and the practical advice that they needed. At this time, I will facilitate the Q&A portion of today's presentation. As many of you have experienced as either caregivers or those supporting caregivers, there are tricky questions that affect what's a right, what's not a right. And Shekinah and Kendra went over a number of the areas that rights exist, so we won't be able to cover every single question in detail, but I'm going to bring up a couple of the questions that came up and where you can get extra help. So the first question is for Shekinah and Kendra. Could you tell us a little bit about what is reasonable, prudent parent standard, and just remind folks how it applies in relation to the Foster Youth Bill of Rights?
Awesome. Great.
Oh, I was gonna go first because you know a little bit more than me, so I was gonna put my little 2 cents in.
Go ahead, Kendra. It's all you.
And just give my layman's term of it is just being able to make decisions that a normal and reasonable parent would make. The same decisions that you would make if it was your biological child and there was something that they wanted to do. I know if my daughter wanted to go somewhere to a friend's house, that I would make the decision that I needed to meet the parents. I needed to know who was going to be in the house. That's a reasonable and prudent parenting standard. It's just just making the reasonable decisions for the safety of the child, but allowing the child to have the freedom, to be a child, to experience it. When we do that presentation, we talk about normalcy, but just a life that they would have if they weren't in foster care. And that anything, like if your child was asking you, can we go swimming at the river? Well, I'm gonna have to go. That's gonna be my reasonable and prudent parenting standard, and you're gonna have to have a little life vest or a life jacket. Just those basic decisions that we make in raising children, that we would use in deciding whether we would let our child go somewhere or do something or participate in an activity, after school activities. Like, is this beneficial for a child to play youth sports, for me to be involved? It's just a decision that any parent would make. So now Shekinah will give you guys the more technical definition.
How did you know? That's exactly what I was gonna do. We have a good little dynamic going on. So as Kendra described, like the thought process behind making an RPPS decision, in technical layman's terms, it essentially was a state law that was created after Congress passed the Preventing Sex Trafficking and Strengthening Families Act. And the purpose of that act was to ensure that normalcy was being supported in the lives of youth in foster care. So as a response to that federal law, California responded by creating the laws called Welfare and Institutions Code 362.04 and 362.05. And those are the laws in our code that actually define what RPPS is. So Kendra said it beautifully. Essentially, that's what it is to make careful and sensible parenting decisions that maintain the child's health, safety, and best interests. And those decisions are created in order to support normalcy of youth in foster care.
Wonderful. I appreciate how you built on each other's answers. We had two questions that were related. One was, if a youth was denied or delayed a referral to mental health treatment by a social worker, could that be a foster youth rights violation? So I'll ask that first question, and then I'll ask the second question that's related.
So any situation that impacts the youth and is regarding their rights, care, placement, and services, and that youth is not receiving what they need in order for them to thrive in placement, then that would be considered a violation. So, for example, in this case, if it was a referral to mental health services, that would fall under the services umbrella. So if there was a slow response to it and the youth, for example, is still waiting for those services to be enacted, then that would be definitely a time where you can contact our office, where we could check in to see what the delay is and also offer technical assistance to the county, the worker, to make sure that those services are being provided in a timely manner. So again, if there's any sort of barrier or problem or even delay with their care, placement, or services, then that would fall within the scope of our office.
Thank you. The related question was a situation involving a toddler who witnessed domestic violence. The caregiver was not informed of the event that happened while away on a visit. And then the young person was not given a timely referral to services. Is either the delay of getting those services a foster youth rights violation, or the delay in letting the caregiver know that they needed to even ask for a referral a potential foster youth rights violation?
So I would say that if it is a case-by-case basis, that our office would definitely probably have to be contacted for us to answer that. So we would have to do a thorough review of what the county's actions were first. And that's the really great thing about our office, is we have access to everything that the county does. They don't know that we're looking at things that they're doing, but we do look at the stuff that they do, whether it's documentation, referrals to services. So if there was an issue of there being a delay and that has impacted the youth negatively, and that is something that we can confirm from our review, then that would be considered a violation of their rights. But again, it depends on the specificity of that case, and then also comparing what was documented and actually done by the county. So for this individual, if you're still having issues with this child services and you feel like you're not getting the help you need to support the child, and the child has not had the services that they need either, definitely feel free to call us, because we can review the case, screen it to determine if an investigation is necessary, and then we could offer help from there.
Thank you so much. So there are multiple questions about either how to report a foster youth rights violation, or what to do if there's a foster youth rights violation, and how to let people know about it. We've had a prior training on how to fill out information for the courts. I'm wondering, how can an individual file a report with your office? What's the best way to contact you, and how many different ways can a caregiver potentially contact your office and get help?
Calling us is the best and easiest way to call our hotline, and then we can complete an intake. We also have now the capability for people to go online and to initiate an intake. We would then contact you for further information, because we would still need to get additional information regarding that. But just like the complaint process that I described in the PowerPoint, is just to give us a call so that we can screen it out, and we can look, like Shekinah said, we have the access to look into the county database regarding any information that is provided to us as far as a complaint, to look for practice issues and to make sure that the county did follow the correct protocols regarding the information that we receive about the complaint. If the youth is old enough as that they can call and make the complaint themselves, I've had youth who are 10 years old call me, and they've had a caregiver that's there as a support for us to actually do the intake of the youth. It's amazing that the advocacy. I had a youth one time who didn't want to leave a placement, and he kept, when the worker came to pick him up, he kept refusing to go, and he called the ombudsman's office, for assistance. Like, I don't want to go. What can you do to help me? So we'd be surprised at the advocacy at some of the age, even though they're young, of them having the ability to advocate for themselves, just with the confidence to know that they actually have rights, and that there's someone there willing to listen to them and to be able to help them. But we encourage you to call our office, because we're there from 8 to 5, and that's the main part of our job, is for us to do intake and take the complaint. Shekinah, did you want to add anything?
No, you explained everything perfectly. I just went ahead and added our number and the website link to the complaint form online, if you all also want to try that route.
Wonderful, thank you. So this is a question that can be for Jen Rexroad, or it can also be for Shekinah or for Kendra. What, if any, supports might be available if a caregiver makes a complaint about a foster youth Bill of Rights violation and then experiences retaliation after, like a child removed from their home?
So if that individual has called our office and they have a case with us, and they can pinpoint that a removal or some sort of action from the county is retaliatory, to definitely provide us with that information. Because one of the things that our office does is that when we do resolve cases, we, of course, our best and most likable outcome is to do it informally, where we can work with the county and with the social worker to resolve it. But if it's to the point where the true youth is being affected and the resource parent is being affected, or especially if it further impacts the youth's care, placement, or services, in this case, that would be the placement of the youth, so definitely notify our office, because there are particular laws in regards to removal of children, and we tend to get a lot of calls related to that. So one, we would also have to add that additional issue to your complaint, the fact that they have attempted to remove your children. We would have to double check to make sure that the removal fell under child welfare law. And if it did not, and it was retaliatory, we'll be able to see that with our investigation. So to just definitely notify our office of any updates, of any actions, and then for us to be able to further our investigation. And that is if you called our office initially, of course.
Jennifer Rexroad, is there anything you'd like to add?
I would just like to add that we now have new placement change requirements where there is 14 days notice is required, and a placement preservation strategy needs to be put in place. So there shouldn't be an abrupt placement change by the county. The only abrupt placement changes that now should be occurring are if they're ordered by a judge, or if there's some immediate, threat or harm to the child, if, for some reason they can't safely remain in the home. But otherwise, we have been directed to send an email to Summer's department as well, the foster care support department. And if Lily, are you able to type in that email address in the box? And then to contact both the ombudsperson's office and the foster parent support unit can sometimes provide technical assistance for abrupt placement changes, or to prevent an abrupt placement change.
The concurrent planning unit will be available to help answer those questions, but I'd also highly recommend that you work directly with the Office of the Foster Care Ombudsperson and seek out additional help, connecting with other caregivers. And advocates provided additional training and information at a prior webinar. Jen Rexroad, do you mind sharing again the link to where the webinars and the materials are available, and how participants can contact you?
Yes, so I'm going to put our website link, and for some reason I'll put it in the chat. For some reason it's not allowing me to answer questions, but the webinar information is on our website, and you can also find our information on the website. And I would just say that somebody put a question in there about foster youth, who provides the foster youth a phone if the foster youth doesn't have one. And I believe that iFoster is still providing phones for foster youth. And if the foster parent is looking for them to receive a phone, but I believe foster parents have to provide a phone for the foster youth to use if they don't have their own phone.
Thank you, Jen. And we're out of time for today, but I would like to thank everyone for attending our webinar. And please be expecting information with the link for registering for our July webinar, which will be about foster rates, allowances, reimbursements, and supplements. So thank you all very much, and have a great rest of your day.
Thank you, everyone. Bye-bye.